Hello everyone, and welcome to How You Brief a Legal Case. Now, we create this tutorial so that students can understand how you go about reading a legal case and key information to look for and pull from the case. So with that said, I'm going to start with the case name, which is Hustler Magazine and Larry C. Flynt Petitioners versus Jerry Falwell. That's the case name. Below that, which we also call the case style, below that you'll see some numbers with lettering as well. That is referred to as the case citation. So this information here is all referred to as the case citation. And those are the numbers that you would utilize if you were trying to locate the case in Lexis. And what you would do is you would take, for example, 485 U.S. 46. You go into the Lexis database via our online library, and then you would click one of the categories that says look up a case. And when you click on look up a case, you have information that you can fill in. One is case citation. You take that 485 U.S. 46 and you'd pop it in under citation, and the case would be brought right up. So you would know you're looking at the correct case, the case that you need to look at for the assignment. Alternatively, you could have used the the parties' names with plaintiff versus defendant, but by using the case citation itself, you know you're getting directly to the right case. So now what we're doing is we're looking at some information here. And you have disposition, prior history. You don't have to worry so much about that for purposes of what you are doing. You also don't have to worry about the procedural posture, but what it does is it gives you a synopsis of what is going on or what happened in the case from the lower court up to the appellate court, which is where you are with regard to this case. And this appellate court is actually the United States of the Supreme Court, so it made its way all the way up to the United States of the Supreme Court. Now, you look at this part called overview that says overview, and what's interesting about that is the overview gives you a snapshot, a very general, very broad snapshot of what went on in the case. But there's key information you can gather from this, which is important. It talks about why the respondent, which was Mr. Falwell, was suing the petitioner, which was Hustler Magazine, to begin with. And so you want to look at that and you want to read and understand why the plaintiff, because the respondent was originally the plaintiff, why the plaintiff sued the defendant to begin with. That's very important. And it was based on a caricature and an ad parody, but for your facts, you're going to get more specific. It talks about what happened at the lower court and what was decided at that court, and then what was found on review, and then we get to the point where we are now with regard to this coming before the court for review before the United States Supreme Court. Understand, when you see the term reversed, that is not the holding, and we'll get to that in a minute. That is actually the result of the holding, which is the holding is how the court answered the question. But then you have the outcome, so it talks about the outcome. And a key point to understand when you look at an outcome is it says the judgment was reversed because respondent was required to show that petitioner acted with malice or recklessness in publication of statements and advertisement parody. So oftentimes what you're going to see is if you see the outcome, that's your issue as well. But the issue is going to be phrased as a question. So you're getting to this point and you're looking at the outcome, which is your holding, and you're also looking at the phrasing of the issue as well, which is the legal question that the court had to decide. Now, all of this information here that I'm scanning down, head notes, you do not need that information, because what those are those are research tools for attorneys and legal assistants and paralegals. Those are research terms so that we know whether we want to even look at this case to begin with. So you can scan past that and you can go down first to the decision, read the decision and see what it said. Again, the decision is your holding, and your holding always mirrors your issue. So if your decision is First Amendment held to prohibit public figures from recovering damages and so on and so forth, you know that your issue is going to be phrased in a similar way, but it's going to be asking the question, whereas the decision is actually answering the question word for word. Now we have the summary. So you go down to the summary, and this is another synopsis, a snapshot of the case. And this is good to read, but please don't think that it gives you all of the information that you need for the case. It simply it starts to set up the case, and the entire case isn't set up, but it gives you a snapshot of the facts of the case, what happened at the lower court, how the case came to be before the Supreme Court of the United States, and so on and so forth. So it gives you facts, talks briefly about the issue, talks briefly about the holding and why, and it talks briefly about the procedural history of the case. And then you scan down further, and now what we have here is we have lawyer head notes. Again, all the information that I'm highlighting right now, that is not something you need to worry yourself with, because that's not something that is part of the case that you need to read. You can if you want to, but it may be more confusing than anything. So you want to go past this, and what you want to get down to is the opinion. You see where I've highlighted the opinion? Because the opinion is where the court is going to actually start talking about the case. And so when we look at the opinion, the first thing you want to note is that the court is going to start talking about the facts of the case. And the facts are your background. Sometimes you'll see the word background. Sometimes you'll see what happened in the case. There'll be key words that lead you to understand that now the court is going to be talking about the facts of the case. And so you look at that and you're looking at, okay, so the facts of the case are the circumstances that actually led the plaintiff to want to sue the defendant and feel that the plaintiff had a cause of action against the defendant. So you want to pay attention to this stuff. And remember that your facts must be specific. They must be very specific, because if you leave out an important fact, you're not telling the whole story. And your facts actually paint the picture of what's happening in the case. So you want to make sure you pay attention to this section. This is going to be the one section in your case brief, when you do create it, where you almost have to copy and plagiarize almost, I say, because you can't change the facts, and you don't want to generalize the facts, because you want to be specific with them. Now, with that said, that doesn't mean every fact is important, and that doesn't mean that everything said in this section is a fact. For example, the district court directed a verdict against respondent on the privacy claim. That's not a fact. That's procedural history. It's not actually a fact. The jury found for petitioners on defamation. That's not really a fact. That's procedural history. So you have to be able to identify fact from procedural history when it's mixed in the background. But it's important to be specific with the facts and to tell the story, because if you leave any out, then you're going to be missing key information from the story that you have to tell. Now what you want to do is now you want to go down and you want to say, okay, so now I've got my facts identified. What's my issue? And how do I go about identifying what my issue is? So now we look at where it starts talking about on appeal what happened. All right, so on appeal, what was the court having to decide? So you have to look at what was the court having to decide. And oftentimes what will happen is the court will actually identify the issue for you and tell you what it is. And look for terms like, this case presents us with. Okay, for example, in this case it says, this case presents us with a novel question. Okay, a question is an issue. The legal issue is a question. That means that, oh, all right, now the court's identifying for me what the issue is. Sometimes it will say the issue presented in this case, or the decision that we have to make is based on. So you want to look for key phrases of that nature that are going to key you in to knowing that this is the issue that you have to identify. And so you know that the issue involves the First Amendment and involves the tort of intentional infliction of emotional distress. So we know that. So now what the court does is it further identifies the issue and clarifies it, because now it says we must decide. Now when you have this, that's another key phrase. Now what you know is the court is actually spelling out the issue for me, and you're like, all right, now I'm going to know exactly what the issue is that the court has to decide. Now I'm not saying it's always that simple, because sometimes issues are hidden within the subject matter when we're looking at things from a different perspective in a case, but for purposes of the Hustler magazine case, here now we've got the court that's going to actually spell out what is the issue in this case. Okay, so we look at that and we're saying, oh, okay, so there's my issue. This is what the court had to decide, and so now I have to determine how I'm going to phrase that so it says the same thing in my case brief. So now what happens is we've identified it. And what's interesting is you look here and it says, this we decline to do. Well, then you know that the court did not rule favorably with regard to the issue as saying, as it was stated. So what happens at that point is the court's going to start talking about its opinion, which is its rationale. And that's the reasoning. Rationale means reason. So that's the reasoning of how the court reached its decision, which is the holding. And so you start looking at this, and now it's going to start talking about the law, and it's going to start talking about the facts of the case and how the facts do or do not fit the law. So here we have at the heart of the First Amendment. So when you see things like that, you know, all right, now we're going to be starting to talk about the case, and now we're going to talk about the rationale. And now we go down, 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 and now for the next pages, up until the end of the case pretty much, up until you see where it says we conclude, you're talking about, the court's talking about its reasoning and its foundation for how it ruled as it did. And now you get to the second to last paragraph and it says we conclude, and now what it's telling you is here's our holding. We just told you why we're going to hold like this, and now we are going to tell you, boom, this is our holding. We just explained to you why, and now this is what it is. Okay, so that's how you read a legal case. You look for these key terms like we conclude, or we hold, or we have decided, things of that nature which give you your holding. You look for key phrases such as the question presented in this case, the issue that we have to resolve, the decision that we have to make, and things of that nature in order to determine the issue. And for your facts, what you're doing is you're looking at what are the facts of the case. What's the background of the case? What happened that made the plaintiff feel like he or she or it could sue the defendant? And in between all of this is the law. And so then you want to look at the law that the court is actually stating. For example, when you look at this, you say, okay, we've got Gertz versus Welch. We've got this case versus that case. Which cases is the court relying on, or is there a statute that the court is relying on in order to support its position? So you look at those things as well. So I hope this is helpful in teaching you how to read a legal case. If you have questions, please contact your instructor, and I'm sure your instructor would be happy to elaborate on it. And if not, you can always contact me. I'm Dr. Eldridge. Thank you.